5 minutes, you have to double that time and cut class earlier. By that time.
Which means at least 7.
Are you aware that our final is on Star Wars Day?
So you have to give the Star Wars. Yes, May 4th.
Wow.
So that means you have to give the Star Wars final in
Yes.
Okay.
We need a Star Wars back pattern with the Empire doing some shady corporation stuff.
He's Empire doing some shady corporation stuff.
You know, the evil empire.
Lord Vader found out from Emperor Palpatine that the Death Star had a fatal flaw, so he sold all his stock, thinking that it was going to blow up and he was going to lose all his money. Insider trading.
That's what the recent movie was about, right? It's like they're selling spaceships to both sides to fight the war, so those guys are making all the money.
Oh, well, that's how war always is.
The machine.
It's a machine.
So did you guys break the news to Will?
Wow.
Then he has to brief all the
Yeah, he was briefing all the
Oh,
pieces.
yeah.
Let's get started.
Since me and Victor each did like 6 on Saturday.
Oh my god.
Oh, man.
Even though I was late as shit because I read the email wrong.
You almost need to brief throughout this.
I know, you almost did it all on your own. Because I was in commissary because I felt like crap.
All right, so tonight, anti-fraud, 10b-5, all this good stuff.
Told you.
Right? Did you guess that? You had a...
I was like super confused as to which chapter.
I thought we were on insider trading.
Well, 11 turned into...
Yeah, I read 13, but I mean,
I read it.
I read
we can do the rest of it. I thought I got through like half of them.
We did, but we didn't. So, well, why don't we just do this? Why don't we jump to 13, and then when we have a whole bunch of time left, we'll go back and see what, if anything, we missed in chapter 12.
This didn't tell me exactly how to insider trade without getting caught.
Well, here's a warning I'm supposed to give all of you guys. Okay?
Oh, from the teacher's
From the
guide?
teacher's guide.
Okay.
As future lawyers, you will have access to a lot of client secrets.
Don't trade on
And
them.
some may find that the information is of the type that trading will produce great wealth. You know, thus the material in this section invites a good deal of role-playing and more generally may remind the students of additional reasons why we should preserve the confidential information of our clients. And we should be able to get through this in 5 classes.
So it's okay to get disbarred for $4.3 million already. It's fine.
Like Vince was saying, I think very astutely, if you're gonna do it,
Too big.
make sure it's an amount that you're gonna be happy with for the rest of your life, right? Because you're only gonna get the one shot at it, so make it a good one. So,
Can I just quit being a lawyer after I find out the information on to like the trade?
are you really ready to start trading?
What I want to know is, okay, so the rule is if you know it, you either need to disclose it or you have to sit on it.
Correct.
So can I just like shout it to the world, hey? But no, because then I'm breaching my fiduciary duty and I'm breaching confidentiality. So why is that even an option to avoid insider trading?
Yeah,
Because
just
it's
tweet
not a
out
feasible
somebody.
option.
Yeah, you just tweet out and buy a Disney stock as we're for Disney or something. I better sell my Disney stock right now, guys, and then I've announced it and I'm selling my stock.
Yeah, buy
Well, presuming you have the authority to announce, right?
That's just what I'm doing. I'm announcing people what I'm doing. I'm not saying why.
I'm just trying not to get convicted of insider trading.
So let me.
I think I'd rather breach my fiduciary duty than get convicted for insider trading.
All right. Inside information. The claim. Here's our general rule. The plaintiff must show that the individual traded in the stock using non-public information that was material at the time. The individual was covered by the insider information provisions right? Either insiders or constructive insiders, such as a lawyer, a tippee, or a misappropriator.
What's the tip? Oh, someone gives it to.
Yeah. The jurisdictional requirement is met, and it's pretty much always met for a publicly traded stock. You've got to have scienture, reliance, and proximate causation. You got 7 elements to an insider claim. Okay, now of course some of them are almost universally met, but
What was the science again? What's the definition?
that's not basic knowledge.
Just knowledge.
You gotta have knowledge, yeah. That's one of those really cool legal terms that makes us different than others.
The difference between $20 an hour and $20 an hour.
Exactly. We say that guy doesn't have scienter. That's lawyer speak. Right, let me define it for it. So, looks like our first big case, Texas Gulf Sulfur Company against the SEC. Willie, you want to start us off?
I'll do it, I guess. So this is quite a long one.
Well, just so you know, we had a lot of fun last week. He got all the long ones. Victor got all the short ones, and it just happened that way.
Sorry. Okay, so here we go. All right. So in this case, we have this company called Texas Gulf Sulfur, and they are looking for minerals, basically. They in October of this year, they conducted a ground survey, and then they decided to drill into this. They ended up doing 5 drillings over the next between October and April. The first one on November 12th showed that there was I'm going to say like a big zinc and copper content, because all those numbers, they're all about 8% and about 1%, and they're all good. But then there was rumors going about that there was that they had found something, and this was based on the flying samples, basically. And so the media got in on this a little bit, and so they released they have a press release on April 12th that's designed to quell the rumors. And so do you want to read the press release, or just?
Yeah.
Okay, so they say basically that the work done today has not been sufficient to reach a definite conclusion, things like that. So the court says that at this point on April 12th, they already knew, and this doesn't seem like very much to me, they knew that there was 6.2 to 8.3 million tons never mind, that is a lot. At 26, 29 per ton. And then they found out that it was actually going to be 10 tons. And then later on, they found out there was actually going to be, like, what was it? Over 25 million tons. So we're talking about 25 times 25 plus a million. So there's a lot of money going on here. So we have 3 people buying shares, and what they did is that they actually it'll be more than that in a minute, but 3 directors buying shares. And what they did is that they went ahead and announced on April 15th that even though they just released on April 12th that to quell the rumors, they announced on April 15th that they're going to that this is a mine strike. But the way it actually happens is important. So they released it, but it doesn't hit, and they intended it to hit the airways at 11 p.m. On the 15th, but instead it appears on the 16th in the morning, and then even later in the day at like 10:30 on the 16th in New York. But as soon as they released it at 11 p.m., they immediately bought stock at, like, one of them did at midnight, and then one of them did, I'll get to that. So, Right, so they bought stock like at that point. And then there's more to this. So then they start laying out rules here for us. Yeah, the essence of the rule is that anyone who trading for his own account in the securities of a corporation has, quote, access directly or indirectly to information intended to be available only for a corporate purpose and not for the personal benefit of anyone, may not take advantage of such information, knowing that it is unavailable to those whom he's dealing. Now there's, so insiders, directors, or management authors are precluded from unfairly dealing. So the rule does not only, I'm sorry, this is the insider rule. It also, we learned, it applies to anyone, but so thus, anyone in possession of material information must disclose it or basically sit on it. So there's a disclosure duty. It says an insider's duty to disclose information or his duty to abstain from dealing in his company's securities arises only in those situations which are essentially extraordinary in nature and which are necessarily reasonably certain to have substantial effect on the market price of the security if the extraordinary situation is disclosed. Now that's interesting because that's not really what happens in this case. This is like they disclosed it and then they bought and they're still going to be held liable. But so materiality. So facts are material within Rule 10b when the facts relate to a particular event and are undisclosed by those persons who are knowledgeable thereof, and it will depend on the balancing of both the indicated probability of whether the event will occur and the anticipated magnitude in the light of the circumstances. So that's our materiality rule. So regarding 4 of these guys, there's a bunch of names here. These guys aren't the directors. They basically said that, I'll go into each one. All right, so first we have a geologist named Drake. He bought stuff knowing that, what did he know?
Nothing.
He doesn't really say what he knew. He advised those of the results of the visual evaluation as well as those informed of the chemical. So he possessed material information. I think that he basically knew, he was the visual inspector, I guess. So he got hit. In addition, a guy named Huntington, who actually just sold the land. So I guess the company was, buying up land around there, and so this guy bought some stock in the company, and that was enough. So it seems a little far-fetched to me. It seems a little like I don't see a direct causation between him. All he knew is that they want my land, or they want land. So, okay. Now here we go into the news not being effectively disclosed regarding the directors. So you have to have an effective disclosure to I think it said the widest media outlet. So like basically you need it on the New York Stock Exchange in this instance to, what's that?
The Dow Jones ticker tape.
Yeah. So to effectively disclose it to the whole world seems like a big rule. So before insiders may act upon material information, such information must have been effectively disclosed in a manner sufficient to ensure its availability to the investing public. Pretty simple, but kind of hard to follow. So, yeah. Therefore, the court concluded that the director of stock management would have violated the rule. In addition, those that accepted stock options, even though they canceled the stock options. This seems like a tag on to the end. They also hit people for like accepting stock options at a time when some people knew and some people didn't know that there was a big mine strike. So I guess if you knew about the mine strike and went ahead and accepted this option, Even though they canceled the option, they still don't like the fact that you did that, and they hit them too.
Right.
Yeah.
So, I mean, ultimately, I mean, if you take this case, or this has a lot of facts, it's got a lot of characters in it, you know, but ultimately it lays the whole rule out, okay? And the first part of this is materiality, right? So you have to identify what is it, what piece of information is going to be deemed material, if any. Right? And this court focused on the K55-1 as being the material bit of information, right? And the rules, you know, very straightforward, right? For materiality, and it gives us a nice rule statement. But if you look at the facts, at least on some level, this was speculative at first,
Yes,
right?
very much.
It was speculative, but what the court looked at in trying to find out whether this was material or not was in the main part was the actions of the actors, right? Okay, this may have been speculative, but as soon as you release it, you guys started buying it up. Right? Why? You thought it was something. You thought there was something there. And, you know, and then they relied on not just those actions, but the actions of the testimony of experts and the testimony of news reporters who cover these types of things. And that was how they determined whether it was material or not. And then ultimately it gives you the rule as to when insiders can trade. Right? They've got the two options, like you were saying. If you got the information, you either abstain or you got to disclose. And the disclosure requirement here was it had to go to be put in the public domain by the medium of widest circulation. Right? And it wasn't until that happened that you can act. You know, even that seems, right? If we're really concerned about insider trading, right? I'm going to disclose it at 11 p.m. and at 11:01, having disclosed it, I'm going to purchase based on this information. When you know nobody has had a chance to see it and analyze it and truly react to it. But this court doesn't require a waiting period, right? It doesn't say you have to disclose it and give the public an opportunity to receive it. It just says you've got to put it out there in the broadest sense, in the widest circulation, and then you can act.
That would make it worse though, because then if you disclose it, like, you have to disclose it publicly or to the board or
You got to disclose it by the meeting with the widest circulation.
without breaching your duty of confidentiality.
Correct.
So just to the people that are aware of the deals.
Well, here,
honestly.
like Will said, these weren't directors, right? Who are these defendants, right? Why are these guys considered insiders?
Because they knew.
They knew, and for the most part, they were all getting checks from TGS, right? They had a connection to TGS that other people in the public didn't have, right? They were either employees or somehow they were connected to them in a way that would give them access to this information. Right now, if you're an employee, right?
Mhm.
And I'm an employee of John Dolan Inc. I hear him out in the hallway. He says, "Oh, you know, I'm about to open up 10 new law schools all across California, and we're going public." Right? Are you an insider at that point? Are you act on it? How did you come across this information? Just based on our first case doesn't seem like you've done necessarily anything wrong, right? Because are you an insider?
I'm not. It's,
Not in the traditional sense, right? How do you come across it? Right.
By the carelessness of the company.
Exactly. Right place, right time.
yeah, I feel like if I'm over here at Starbucks and I just put off of it, I feel like.
Right.
And then they can't trace it. Like, how are they going to find out that you're insider trading? You probably still are insider
Because the
trading.
SEC is going to see that you made millions of dollars off of the stock market and then
That's the whole point of the
investigate
stock
you.
market.
But you don't have any connection to the company.
Well, look at the next guy. That's exactly what happened.
So let's go. Chia.
So, this guy worked for a printing press. As he was doing his duties, what had happened was he got the notice that these two companies were these companies were going to merge, I think is what it was. And so he, although all the names and stuff like that were blacked out and he didn't know who they were, he ended up finding out who they were. And he ended up buying their stock. And he made slightly more than $30,000 in 14 months. Lucky him. However, the SEC got suspicious and they investigated him. And ultimately, he entered into a consent decree in which he agreed to return the profits. And he was ultimately fired from his job. He was ultimately indicted on 17 counts of violating Section 10B. And he was brought to trial and convicted. And basically, the court said that in order to be convicted of insider trading, you have to have a fiduciary duty to the company in which you were trading against. And they said here, he came across the information while in the course and scope of his job. He has absolutely no tie to the other companies in which he was trading against. And just because he came into that knowledge, it's not wrong for him to use it in this case. And so they ended up reversing all of his indictments.
Right.
And basically said there's no fiduciary duty, so therefore you don't have to worry about anything.
And if you look back at TGS, not only here, because you not have a fiduciary duty, if there's a duty to disclose, he's not one who holds that duty, right? But then we have a pretty, strong defense here that kind of throws into the mix. Well, wait a second, this guy didn't come across this information in an innocent way, right? And the dissent kind of puts forth this sort of misappropriations theory of liability. So maybe you don't have a fiduciary duty, but if you came across this information in illegal ways or inappropriate ways, then maybe you could be convicted of insider trading. Now that's the dissent. That's not the rule. The majority didn't go along with it, but both seem reasonable. Right? If you got information, right? If you're the janitor and you come across information because somebody's talking in the hallway, and
But if you're the janitor, you work for the company. So you
Right,
probably.
but do you have a fiduciary duty to the company in that role?
But under the previous case, they just allowed people that sold land to them,
And this is clarifying that, right?
Okay.
This is clarifying who the rule applies to, right? TGS kind of gave us a rule, and now this is talking about, okay, well, who does it really apply to? Who can be an insider? Who can be pursued in this type of case?
So working directly with the company insider, working tangentially with the company not an insider,
Right.
according to this case at least.
And here, he had no fiduciary duty. And as we see it, as we go through these cases, it gets a little more specific, right, once we get to O'Hagan.
So does he get his money back?
I don't know if I didn't see in the case where it said if he got his money back, but arguably if you're.
I mean, if you're not found guilty of anything and no wrongdoing, they have no right to keep it at that point, I would feel like.
They've already spent it.
My guess is it's going to be no.
That's a guess.
Oh, you gotta get your money back.
Why not? He didn't do anything wrong according to the court.
What happens if a civil forfeiture goes through and then gets overturned?
Well, that's why I think ideally you should get your money back.
Right.
I can tell you in all my years in the DA's office, I don't remember anybody getting their money back.
Okay.
Because I know there was like that one Supreme Court case, I think, where they said they arrested a drug dealer for something and they ended up taking like millions of dollars from him. And the court came down saying the biggest he could have been fined for this crime was like $100,000, and they took millions from this guy. And they said that ended up violating the 8th Amendment because you can't just take everything when the worst he could be punished with is $100,000.
Right. And that was a forfeiture proceeding on that case. But I don't know if he got his money back. Right.
I mean, at that point, it's probably kind of the department.
Yeah. I mean, I can't imagine them saying, yeah, we're going to return you your proceeds. Maybe it turns into a civil case, a civil judgment.
For an unjust enrichment type thing. I mean,
but I don't know. I don't know the answer.
And they have a qualified immunity, right? If you're suing them civilly, you're gonna have qualified. You're gonna. You got some roadblocks. I don't know.
basically you're screwed. You went through all this, paid all these lawyer fees, and you don't get anything out of it except your name cleared.
Yeah.
I'd rather have money.
Yeah.
Doesn't take the money away.
Yeah. I'll take the shit name with 30,000.
So yeah, it's that is a good point. I do not know the answer to it, but it would make sense that
You get their money back.
if it's overturned, that you would be entitled to it. I think the argument's going to be you have to have obtained those proceeds legally.
So according to them, he did.
Well, in
I
this
mean, that's
case,
what the court says in the end.
in this case, but if it's like
overturn on
Drug.
technicality,
If it's like drug,
fruit of the
like
poisonous
that.
tree type thing.
I don't know. I don't know if you would. I mean, hell, we don't even give. I still say we a lot. Catch myself. we don't even give like firearms and stuff back.
Oh, really?
Yeah,
That's not
it's hard. It's
Really?
really hard to.
So
get.
they like come. They just like confiscate your gun for like.
For a crime.
Yeah, for a crime, and you don't get a. Wow.
Yeah.
That's messed up.
Yes.
Well,
That's messed up.
they get destroyed.
I'd sue you for replevin. Give me back my crap.
And you know what? I've never heard anybody.
Nobody's ever tried it?
I've never heard.
Well,
anybody
it's because it's a state agency, so I'm sure they have immunity.
Yeah, and I'm sure that most people are thinking, okay, yeah, this guy. I mean, he agreed to the deal.
Well, probably because you thought it was going to save him from the indictment, so
Right.
they're just like, oh, we're going to indict you anyways.
And I think there's probably a big part of that where there's a sense of relief where, okay, man, dodge that bullet. Oh crap! Now I want my money back. So do I want to start poking this bear and then all of a sudden other potential indictments come down the road, or like no, maybe you just leave well enough alone. I don't know the logic behind it, but I know I never. Every once in a while, we get a call from somebody that wanted their gun back or something like that. I'm like, sorry.
Let's get the fair market value of it back.
Yeah.
Yes.
Well, because if you think about it, you got a gun. It's been seized by law enforcement. It's been tied to a crime, and we can't tie you to it. Right? You're not charged, but it's still
No.
evidence.
Well, has it been
of a crime.
tied to a crime, or is it you just confiscated it because they may have had it on them when you arrested them?
They gotta have a reason to take it. Right?
Well, what if it's just that, like, you get accused of like hitting your girlfriend, and they come and take your gun, and you don't get it back? Is that how it is? They destroy it?
No, and on something like that, it's if you're turning in a gun for a period of time,
Right.
no,
Okay.
that's all managed separately.
Oh,
But if it's seized
Right.
as
As evidence of a crime.
evidence of a crime, or you're a convicted felon, it doesn't matter if you had these guns legally before, you're a convicted felon now, you can't get them back.
right.
You know, well, you know, I want to give them to my dad, I want to give them to my brother, I want to give them to my son, whatever. Nope, you can't have it. They're registered to you. And the penal code lays it out pretty straightforward how these things are handled and how they're destroyed. And it's not like people are getting your guns and, oh, look, I got this really nice gun. And in fact,
should
it's
sell
the
them.
opposite.
You should sell
They're really nice guns
They
that
should
get
sell them.
destroyed.
Well, why don't they just sell them? Wait.
Put guns back out on the street, you crazy?
No, I mean, you sell them to a proper gun owner, like. Never mind.
Police auction off all the guns.
Yeah.
Yeah.
But then they have to do background checks on everybody, and I'm sure that they
It's
want
not-
to
it's not
incur
good
that
work.
expense.
No, they would make money on this. Absolutely. I mean, they don't sell all of them, just the ones that are awesome.
They're awesome.
The ones that didn't kill anyone.
You know, these guys, a lot of the stupid kids, gangbangers and whatnot, they have the cheapest guns.
Yeah.
Just, they're not nice guns.
The yellow mark $200.
They're little
guns.
Tauruses and there's, so I was like, what is this? Does it even have a brand name on it? What is it?
Made in China. Just-
There's this, maybe it's called a Taurus. There's this type of gun that keeps popping up. Is it Taurus? I don't think it is. I think it's cheaper than that. That doesn't matter. Sorry.
Well, it's so funny too how expensive guns are here, right? I look at guns here and I look at the same guns and
How much do they have been here?
Well, it depends. I mean,
Like a 9, like a.
if you want to get a nice 9mm, you're paying $750 to $1,000.
Easily.
Easy.
You could pay up to 3 if you really wanted to.
You want to get a cheaper one? Yeah, you can get one.
No, I'm 3,000. But
Oh, easy.
You can get a cheap one for like the cheapest thing you're gonna buy is probably $200. The cheapest thing you're gonna find. But but you could go
Vermont,
to,
they were like
Well, that's what I told you.
$300 for a good handgun.
You go to Colorado, where my son's at, and they're ridiculously cheap.
really?
And the same model, same brands. Wow, I just paid that for that. Whoa, what the hell?
Oh.
But of course I can't buy over there.
You get like a hunting rifle
You know.
for like $60 in Vermont. I mean,
Easy.
it's cheap as hell to get a gun in Vermont.
Yeah. Yeah. And it is in Colorado too. I'm sure there's a lot of other states that's really cheap.
It's very the gun-friendly states.
But not California. California kills you. So, you want to tell us what O'Hagan does?
Yes, so he actually.
It's my future.
He's the future.
You see who's delivering the opinion of the court?
Ginsburg.
The ghostwriter.
Alright, so this guy, he worked for a law firm that was representing this company that was gonna like offer a deal to Pillsbury, that company. So he had this information. I guess when they say like they're gonna trade to offer common stock, I guess they're gonna increase Pillsbury's value, right? Because they're gonna be part owner of this company that's offering it. So knowing this information, this gentleman goes and buys like a ton of these stock options where you can purchase, you can sell those options later. He goes and buys a bunch of actual Pillsbury stock. And he racks up a nice little nest egg of like $4.3 million in doing so. But, the court goes into this whole analysis saying, because after this he got like indicted, he got convicted of fraud and insider trading and all that. then the Court of Appeals reversed it, but now they're trying to reverse it back. So he almost got away with it, but they didn't let it go. So now they're trying to see, well, there was no mail fraud because there was no underlying fraud, but then they're trying to see where was the underlying fraud, and then they're looking at this rule, which I guess is the title of the chapter. It's a rule section 10B, which is pretty much using information that should have been confidential, and using it for yourself or for anyone else, is the underlying fraud. It's the misappropriation of this information that should have been the exclusive right of the persons who knew the information. So this whole like Pillsbury Valley's gonna go up, that right only, I guess, that only belonged to this company that was offering Pillsbury the common stock. And to use that knowledge for your own gain was the underlying fraud based on the rule. Let's let him go to get his freedom reversed. Now he's being indicted for it being good.
Right, so they basically took the dissent in our last case
Mm-hmm.
and said, wait a second, there is such a thing as a misappropriation theory. And
Yeah, so
they used it against O'Hagan.
yeah, I've had a couple of these. If he trades on the basis of material non-public information concerning a pending tender offer that he knows and has reason to know has been acquired directly or indirectly from an insider of the offerer or issuer or someone working on their behalf, Rule 14E-3A is a disclosure provision. It creates a duty for those traders to fall within its ambit and abstain or disclose without regard to whether the trader owes pre-existing fiduciary duty or respect to confidential information. Yeah, they got this information from somewhere you weren't supposed to use it.
Right, so if you just look at factually, right, is this that different than Chiarella?
It's not that different, but this guy's like actually a lawyer in the firm. Like,
He's in a much more confidential
Yeah,
relationship.
so-
I mean, he has a duty to the corporation because he is an agent of the law firm that's representing them. He found out this information due to protected, confidential communications between a client and a law firm. I mean, I think there's a much bigger difference between a notice in a newspaper, which technically, because of the notice in the newspaper, it was about to be disseminated to the public anyways, imminently.
But, okay, if you take post-Hagan, right, this is a U.S. Supreme Court case. Wouldn't Chiarella be a misappropriator under Hagan?
Why would you
I don't want to be a misappropriator at all.
No, I'm just saying, wouldn't he be found to be a misappropriator under
under Hagan?
Under Hagan?
Yeah.
I don't know, because I still feel like the relationship is different. I feel
Well,
like
the relationship is different from a fiduciary standpoint. But how he came across the information, right? He wasn't
I mean, he wasn't on the case, but I think he went searching for it.
right.
Whereas in Cal, or whatever the other one is, the Cheetah one, basically, it just kind of fell in his lap. I mean, he didn't go looking for it, and I mean, he didn't have a. I just feel like the standards are different between an attorney and a newspaper article writer. I mean, I don't know.
No,
I mean, he would be found guilty if O'Hagan was the standard when he was tried. I feel like,
and that was kind of what the dissent was saying, right? And what Berger was saying, and Chiarella, it was, hey, look, you know, maybe he didn't have this fiduciary that clearly O'Hagan did have, right? He had a duty, you know, to keep his clients' information confidential. But here you've got now this whole misappropriation concept, right? That basically, right, if you're committing a fraud, in connection with your securities transaction, right, then you violate 10B and 10B5.
You know,
So, so let's see here real quick.
So can he use like the 4.3 million to pay his legal fees, or is that like?
It's already been confiscated by now.
It's already been frozen?
Yeah. So here's
I cash it out real quick, we'll get a bunch of hundreds if I have to permanent measure.
so here's our duty, right? It arises in right. Your duty to disclose or abstain arises in three situations, right? You're either an insider, you're a tip recipient, or you're a misappropriator, right? Insiders are those people with a fiduciary duty who hold material information, right? Outsiders who receives tips, right? They inherit a tipper's disclose or abstain duty only if the insider breaches his fiduciary duty by tipping, and a tippee knows or should reasonably know that the insider is breaching his duty, right? Mere receipt of a tip from an insider does not by itself impose a disclose or abstain duty on the tippee. And then outsider who misappropriates confidential information breaches a duty owed to the source of the information and violates Rule 10b-5 if he trades using that information, right? And then of course that's O'Hagan, right? Where the lawyer buys the shares of his non-client before the deal.
Can there be like a disconnect between duties? Like, say, I'm friends with someone at Disney, and he tells me to buy Disney or when to sell it, but I have no connection with the Disney company. Is he the one that's liable for me buying the stuff?
He's imputing his insider knowledge on you, therefore
Would I be an insider trader?
you would, because you're getting insider information from an
What if I don't know?
insider.
What if he just says I recommend you buy some now? Like, he's not telling me why, it's just buy it.
Well, he just giving you a recommendation.
Yeah, he's just saying buy the Disney stock. Right? He doesn't tell me why. What do you know?
Okay, well let's just assume who we're talking to. I'm talking to my business professor who doesn't have any connection to Disney.
Mhm.
Okay? Or I'm talking to somebody that I know is on the board of director of Disney.
Mhm.
Wait a second. Should I know that this person's got inside information? Right? Is it reasonable to conclude that that might be insider information based on who they are? Right? So it's one of those situations where if you have reason to know, to suspect, then you're on notice. Right?
It could also be a scam. It could be trying to ramp up the price before he dumps it on us.
I feel like the insider trading rules just go too far. I mean, they're too inclusive. I mean, how can you impute your duty on somebody, on an unwilling participant? Like,
What if they don't know they're
say your whole John Dolan thing happens. Like, how can I now have a duty to keep that quiet when I didn't get it in any kind of a fiduciary way? I mean, if I'm just sitting here and they're being irresponsible with insider information, I don't have a duty, I have no duty to keep that information secret and to not utilize it. Like, if your corporation is so...
But yet the law puts their duty on you.
Even if they're being irresponsible and
talking super loud at Starbucks.
I mean, how would a normal person know that? I mean, that's the problem.
Well, I guess that's, look, if you take it out of the context of the law school, right? Clearly, if any of us here heard a conversation, where John's saying, look, I'm going public, I'm expanding, we got big things coming, right? We're about to be accredited, and this thing's gonna blow wide up, boom. And you're here and you hear that, We all know who John is. We all know, right?
Yeah.
And that's going to be imputed on us. If you're at Starbucks and you don't go to the law school, you're never in court, don't watch TV, and you have no idea who John Nolan is, and there's just some guy standing in line behind you talking, is that imputed to you?
According to the SEC, probably.
Right. They're going to try to, right?
And then you're gonna lose your money anyway.
Right, because it's kind of a catch-22 because, well, wait a second, I have no reason to suspect that. And they're going to say, but who else would be talking like that? Right? Who else would know that? You had reason to suspect this was somebody with knowledge, and that's why you acted on it. If you didn't think they had knowledge, you wouldn't have acted.
Then I wouldn't have, exactly, but that's the whole point. But that's what's insider trading, I guess, but it's just.
It's almost impossible to make money on the stock market without the SEC thinking that you're
Sure.
Yeah, because I'm thinking, like, if I see some guy, like, in an Exxon uniform at Starbucks, and he's, like, covering oil, saying, like, we just discovered oil yesterday.
Mm.
Like, I'm like, his uniform, like, I should probably buy some of that stock, you know? But I don't want that to be insider trading, but even though he's the first to know, this company just discovered oil somewhere. But does that impute the knowledge? Like, if I just happen to know it and not believe it?
Well, real life situation is I don't think they're ever going to be able to prove that you got it from insider knowledge if you have no connection to the company.
If you
So, I
shut
mean,
up.
if you shut up. If you're just in Starbucks and you're like, I asked a fortune teller who I should invest in. And they're like, Exxon. I mean, there's no way they can, in the real world, there's no way they can tie it in that you got it.
There was a lady who just recently won the lottery like 30 times. And
what?
Yeah,
She won the lottery.
She won the lottery. It's not 30 separate polls. She said that these numbers just kept appearing to her. And so she picked those numbers, and she was so confident in those numbers, she went to 30 different locations and bought 30 different tickets.
Oh.
All with the exact same numbers on them, and it won. Okay, you might be thinking, wait a second.
Just have to split it with yourself.
How do you know? You bought 30 different tickets on them, And she said, the numbers just kept appearing to me. I don't know, this stock just kept appearing to me. I thought I'd buy some.
I mean, they have to be able to prove that you got it from insider information. And then if there's no way to prove it, then...
And the reality is, it's got to be worth their time too, right? How much are you buying it, right? I want to put $20 on Disney, right? I want to get my 1/100th of a share. Yeah, they're not, right? But if you're pouring significant money into the stock, it's gonna
raise alarms.
Yeah.
So, why would you buy more than one lotto ticket with the same number? Why don't you just split it with
We just win once.
Yeah.
Because otherwise you're splitting it with yourself.
She ended up.
I'll give you more.
It was kind of interesting. It was like, I was shocked. Just like you, woman wins lottery 30 times. Like, what?
I know.
No. It's funny. She still got millions of dollars, but I wasn't as impressed that she bought 30 tickets with the same numbers.
Well, but that sounds much more fraudulent to me than actually, like, I mean, eventually it's going to happen that somebody's going to win it 30 times. Like, it's like going to take, millions and millions of years for someone to get there, but like you would think. But how do you know the numbers so well?
But the lotto is so random.
I don't know. They're both.
You can't set up the lotto. That's
But I kind of like you were saying,
You
if
can't.
this number's gonna hit, I win. So if I'm buying 2900 tickets, why am I gonna buy these same numbers?
Yeah.
Right.
And
You're basically
split them?
wasting money at that point.
Yeah.
Well, so how do you set up the lotto?
You can't. You literally cannot set up the lotto.
No, but you talk to any lotto winner, they all thought they were going to win. So no one ever buys a lotto thinking they're not the one. They're just thinking this is my chance right now.
I don't know. It just seems crazy to me. That's mostly what it is. It's just like a freak thing.
Yeah, everyone thinks they're going to be the next winner when they buy it.
So they go buy 30 of the same ticket?
That's what's
It's
suspicious.
the same
Like,
number.
Yeah. That was
$60
suspicious
into
to
the
me.
same pot, like with the same number. Like that. Right.
Maybe I'll lose one of my tickets. That now I have 29 backups.
No, you know what would happen? Would that diminish? Like if someone else won, would they only get like 1/31th of it? And then she gets
I would
like
think so.
30. So she's hedging her bets. Like if she wins, she didn't want to split it with anybody. She's entitled to like a 30%,
Yeah,
30 times more money than the other person.
sure.
That would.
To me, she didn't seem like she thought it out all that well.
She decided.
There's a 1.
I know.
There's a 4,
Right?
Freaking long, man.
The number. And this was recently.
I don't know.
I heard this like within the last month.
Remote that.
I never played either because I'm never gonna win.
Yeah.
If I don't play, I'm never gonna win. So
It's funny. It can be like 100 million. I won't play. 300 million. 400. Oh, I gotta play now.
the billion range. That'll start playing.
As
but-
to one's own life,
Right.
the difference is really, you know.
I don't want to win 50 million.
Yeah. Who wants 50 million? After taxes, you get 25 million. Not even worth it. Not worth the $2.
So, Dirks.
Okay.
Raymond.
So, right, so Dirks is this officer and here broker dealer who basically is going to investigate. So he hears from this guy named Ronald Sechrist that this company is the equity funding of America is grossly or vastly overstating its value, and it's basically fraud. And so he starts investigating, and in the process of asking all these questions and starting to find some information, a bunch of people pull out and liquidate up to 16 million of their holdings. And so the share drops from 26 to 51 because this guy's investigating, and it ends up being like basically real, you know? But the problem is that is this guy liable for telling people about, so basically he saved people a bunch of money that were wrongly invested, and like is that insider trading? And but I mean technically under the rule it was literally because you know he was a tippee and he had a fiduciary duty to the shareholders, not if he received material or non-public information to either disclose it or whatever. But he he just kind of like in the process of his investigations, some people found out, some people didn't. It wasn't like it wasn't really a disclosure. So basically, the Supreme Court held that the 10B should not be read this way. That it should not. First of all, basically, he didn't breach a fiduciary duty because his conduct wasn't.
Self-serving.
Yeah.
Basically.
There you go. Yeah. Yeah. That's basically it.
Yeah, I mean, this is kind of backwards
Right.
insider trading, right? You're not necessarily trading on the information for your own benefit. You're trading on you're putting out bad information that causes it to fall. And here they kind of jump back to the fiduciary relationship analysis, and not only did Dirks not have a fiduciary relationship, right? The court even said that Sechrist didn't either, right? It wasn't even a violation of his duty. So, right, in this case, he little guy fought and won. Took it all the way up to the Supreme Court and ultimately won.
Yeah, after the SEC didn't do anything about it, he did something and then they arrested him.
Right.
That's
That
sad.
seems so backwards.
It does.
We didn't do our job. Thanks for doing our job for us. Okay, now you're arrested.
You know, it's when I was going through this one, I was reminded. I had nothing to do with this case, but it was a really cool case. You guys may know of a trucking company called Burgess. See them out on the road. And, well, Mr. Burgess is a very wealthy man, and he resides out in Beaumont, California. And he was appointed to some commission out in Beaumont for the city, and something happened, and the FPPC came down and fined him like $5,000. And you know, for him, $5,000 was nothing. And he fought it and fought it and fought it. Our firm was his lawyer. $375,000 worth of attorney's fees later, he won an appeal. And the FPPC ended up having to pay all of his attorney's fees and costs, and
For a $5,000 fine.
$5,000 fine.
You know what? I think that's great.
You know, now,
Yeah.
are we gonna do that?
No.
Probably not.
Yeah.
We're gonna cry about the $5,000 and we'll be like, okay. But to some guys, I don't know. Nothing here said Dirk was a wealthy person, but it just struck me that, you know,
He was. I mean, he was, what was he? He was he was an officer of a New York broker-dealer firm who specialized in providing investment analysis. I'm sure he made pretty bad.
Maybe well, it's possible. It's not, maybe that would have screwed up their like to have one of their officers convicted by the SEC may have been bad for their business, and so the business took it up and you know brought it for him or something like that. I don't know. They don't want their officer like convicted of you know doing something bad.
well, it's funny because that was one of the elements that he had to demonstrate and able to get his attorney's costs is he had to demonstrate that his suit somehow served a public purpose or was a benefit to the
Really?
public. Yeah.
Okay, I mean,
And they were able to do that.
I won fees on the public interest doctrine,
Yeah. And
but yeah, that's interesting how that case could. Okay, I mean it's public interest law basically, but you can get it for a lot of things. It's a wider suit. It's a wider provision than
Right.
Right.
and you know they tell that story around the firm. Oh yeah, we fought that $5,000 fine. You know, cost them almost $400,000. Oh, all right.
Now stick to the government.
Yeah, exactly.
All right, let me just read a couple notes here for you. You might ask, why don't you see more class action for insider trading violations? And basically it says with respect to the ceiling on liability, the non-open market purchasers could sue for more than the insider's ill-gotten gains. Also, given the manner in which insider trading is detected, namely from market surveillance efforts and tips to the SEC, centralized detection leads to centralized enforcement so that any private suit would largely be parasitic. You know, I get that. I guess from you know, if you're looking at how is it that a class action could be profitable, it probably wouldn't be, right? Because you're going to have this ceiling of what the liability is, and yeah, the way that you would find out about it, you wouldn't. Right? The SEC is doing the investigation, or there's tips that are coming in, and right, we could probably give a tip right now that hey guys, SEC watch Victor. This guy When he makes moves,
Oh, there's something.
there's something there. Just watching, right? It would be hard to, to start something that big, even though in theory it would be potentially available.
And then I get part of the fines that are levied against you.
That's not fair. So that'd be our insider trading. You kick you back some of those fines. I'll go down.
I thought insider trading is kickbacks. It's a crime, right?
Let me make this like giant like $1 billion fraud. You take it up against me to get a.
Yeah, there's some
and
article.
you'll split it with me.
There was some article about some insider whistleblower that got like $33 million from the SEC for a whistleblower action that they did. I'm like, what?
So, are you entitled to some kind of percentage or something like that, or
It's
why
in
don't they give up $30 million? I mean,
it's in the code section. Like if you turn your company in and they're doing something illegal, you get like you can get a portion of whatever fines they levy against them.
I don't know.
A lot of like companies like Microsoft do that too. Like if you're working for someplace and they're illegally using copyrighted like versions of Microsoft and you turn them in, they'll give you part of the fines and stuff like that.
So I'm saying you gotta be like a level deeper on the inside. So you do the crime, but then you have someone whistleblower you and just split that fees later. That money is clean. And you retire off of that money. Just give up the big money. But you get the money.
Then that's at Ocean's 11 over
Yeah,
here.
exactly. I think that next level.
That's just real quick before we get into Diamond. Let's talk a little bit about the note of who an officer is. And a good illustration of the current interpretation of who is an officer is found at Livingston, that they mentioned there, where clearly an honorific title is not sufficient to push one into either the reporting or short swing profit provision. Given the prophylactic purpose of Section 16, it seems to be overkill. People like Livingston who are brokers but not managers in Merrill Lynch just don't pose a threat. It's important to know who is an officer because reporting functions require those reports to be filed and promptly by the officers. So 16B, of course, is dealing with the those who trade, whose job it is to trade in the market. And just a quick note on deputization. While a fairly arcane subject, it's not really at all that rare an event for a company that has a substantial investment in another entity to place a representative on the other company's boards. Consider the venture capital firm that retains a stake in the company that has made its first IPO. Might not its continued presence on the startup's board post going public lend itself to the reach of 16B, and should it purchase and sell shares in the startup within 6 months? So arguably there is a manner in which you can be pulled under 16B, even though you might only be there in this oversight type of role. And then we come to Diamond.
So in Diamond, what had happened was this was a derivative action brought on behalf of corporations, shareholders on behalf of corporation against two of its directors because the MAI, who is the company that Oramuno worked for, they dealt with computers and everything like that. Ultimately, it was decided that they were over marketing what they were able to do, and it ended up having to become necessary for IBM to come in and service all the machines that they were selling. So the company was about to take a pretty big crash because their expenditures far exceeded their profits. And so before the information became public, two of the officers of the corporation, Oramuno and Gonzalez, sold off 56,500 shares of their stock, which at that point was $28 per share. Ultimately, the information was released, and the stock tanked from $28 a share to $11 a share. So they were able to get just about $800,000 for their stocks than what they would have been worth after the public knew of the information. So the shareholders brought a derivative suit stating that you owe the corporation back this money because you illegally got it from the corporation based off of insider knowledge. The two directors basically admitted that they did it, but they said that, it doesn't matter that we did it because a corporation can't sue its directors for insider trading, basically, because there's no damage to the corporation. Basically, we sold our stock, and it is what it is. And the court said that that's not true. They said that the premise of 10B, or I think is it 10B or 16B? No, 16B, or 16B in conjunction with 10B, says that damages really isn't a important part of insider trading. It's basically that you did something that you realized money on something that you used insider information for, and damage is not an integral part of the suit. So basically they're saying here that there doesn't have to be damage in order to get a 10B conviction. And they also said that although there's no monetary damage to the corporation, there's the damage to the goodwill of the corporation, and there is basically derivative damages to the corporation, although there's no monetary ones. So they said that basically a director can be liable to a corporation for their illegal insider acts that cost the corporation money under 10B.
Were they required to disgorge their?
We don't know. No, probably, but this was off the motion to dismiss, so they just said, no, you can go forward with the trial. But yeah, they're probably going to be.
They're probably going to be, right? And that has, right, if you just look back at the last few chapters, right, there's been that's a common remedy, right? That's a disincentive that statutes put in place so that officers and directors don't abuse their position of authority, and that whether it's taking opportunities or self-dealing or what have you, there's this concept of, hey, if you do it, right, you're going to be disgorged of any gains you get. So don't do it.
So does the corporation get these monies back, or does it just go into the SEC's pocket?
I mean, I think when you're talking about disgorgement, it's definitely going to come back to the corporation. If we're talking about fines and stuff, I think that's where the SEC is going to get involved. But here, these guys really didn't realize money. It's just they saved themselves some losses.
Yeah.
Right? So it's not like they have $800,000 extra cash. It's just that
they kind of do because they sold their stock. So I mean, they got the cash.
they got the money value of it.
So I mean, they technically have the $800,000 to pay, but
Well, I'm not sure they sold it, right? They didn't sell it for $880,000. They just
no, that's the profit that they made based off of what they sold it at and then what it was worth.
what it was worth after the shares tanked.
Yeah.
Right? So I don't know. But let's say you share it at $28 a share, and you make.
They made $1.6 million.
Okay.
So they have they basically doubled.
But you can argue. Let's say you sold it and you made $500,000. but it really tanks, right? And what it's worth by the time they bring a suit, you've saved yourself losses of 800,000 or $1 million. But arguably, you could be held liable for disgorgement for amounts greater than you actually received, right? Because it's not, in this particular scenario, you're not necessarily realizing the profit. You're avoiding the losses because the stock tanked, not because the stock went up, and now you can sell it at that greater rate.
Is your duty to go down with the ship, essentially, or what's
If you got insider information,
to go down with the ship? The ship is sinking. You know the ship is sinking.
if you got to do to, you got to convince them to disclose, and then
How late after disclosing do you have to wait? Like, can it be same minute?
it doesn't say, right? We've gone through the whole chapter, and the rules don't give a time frame.
Well, it could be in a supplemental.
Well,
I don't have access to it.
let's look.
Yeah, to disclose you. So you say the company's going down. Everyone sell, and then you sell.
Yeah, I
You tell
mean,
everybody like to sell.
you do the one, like, especially for that one case, the Dirks case or whatever.
Mhm.
Like, he told the Wall Street, he tried to get it out there, and the Wall Street Journal didn't want to do it because they were afraid that it was libel. And I mean, so it's not like he didn't try to get it out there, but
You just tweet it.
They just
tag
wouldn't.
the company, and then-
I had read.
and then in the first case, didn't they disclose it? Didn't they have the press release and then they
They just,
bought the stock or something like that? Like,
they disclosed it, and then, yeah, exactly. So they disclosed it, and then they started buying it up over several transactions. But,
yeah, but they had fully disclosed and they were still found
yes,
liable, right?
because it's at the point where the media has just disseminated.
But they were still found
They
liable for breaching
yes,
10D, right?
everything before the
The media release.
no, everything before the New York Stock Exchange put it on the ticker. So it didn't matter that it was in Canada. It didn't matter. They held a while for everything before it was on their
On the ticker.
on the ticker in
Or were they not a publicly traded company yet? Well, no, they had to have been in
Yeah.
like their stock options.
yeah.
Or no, I guess not.
So what they did is they did it too early, basically. Like you can't do it that minute.
I think you should.
You have to do it, let everybody know about it, and then you can sell, like with everyone else.
Technicalities.
Yeah.
Yeah, I mean, because when you think about it, okay, you put it in the Wall Street Journal, right? You stick it on the Dow Jones ticker. It's out there.
It's out there.
So conceivably, anybody can begin acting on that.
Yeah.
So once you disclose, I have not seen anywhere where there's a timing that says this is how long you have to wait. There's like a waiting period. It's, hey, you put it out there, but it kind of seems like if you know you're going to act on it and you know that's why you're disclosing it, right? You got your broker on speed dial, right? You got your
You should probably wait till market opens the next, like do it at night, in the middle of the night. You know, like I did at 11 o'clock, and when market opens, do it.
Abandon ship.
and then you find that all the overseas buyers have bought up your stock.
Yeah, exactly.
Right.
You know,
Yeah, that's
damn
true.
it, missed the opportunity.
But
And now
that's,
I'm going down with a ship.
Yeah. So, not good. Yeah, I think the government's trying to keep the man down, so they don't want you to get too rich. So
Trying to keep the man down.
So we went through
5 class periods now.
we went through there very, very quickly. You know,
5 classes, 5 cases.
piece of cake.
Okay, so
One case per class.
And we've only got one more
Class.
chapter, and then we got review, and then we've got
graduation.
graduation.
I made the 4th finals and then graduation.
You know, I gotta tell you, now you guys have challenged me, right? Instead of a baseball writer and, you know, and the lion will sue, and it's like, okay.
Yeah, but we're smart enough to know that it's happening under American law.
You know, you're not gonna, protest and file a grievance. That's great. Like,
Why would you not apply the law that you learned? This is like,
Because we're part of the Trade Federation. We are not part of the Galactic Empire. Therefore,
I want to.
The laws are different.
Don't tell me. But it'd be nice to know who the heck, like, wouldn't think like.
who argues that, like,
Well, it's Star Wars. I didn't know we were doing American law. Exactly. It's ridiculous.
who thinks that argument's gonna fly? I mean,
Those statements are easy. The Emperor said so.
We're in space. The Constitution doesn't apply in space.
you guys may know that I have a little video game that I play from time to time. There's right now everybody's kind of in an uproar because developers keep inserting Old Republic content, and if you're big on Old Republic, it's great, but
I love the Old Republic.
with Old Republic
There's not
content,
canon.
no, and they keep inserting it, and it's like all the most powerful, characters are Old Republic characters. It's like, come on, man, you're killing us. Palpatine's weak, he's weak. Vader's weak.
Compared to the Old Republic guys? Oh, God, yeah.
Absolutely.
I'm a nerd.
I don't know anything about the Old Republic.
It's based on video games.
It's an
for
old,
the original
like, PC.
Xbox. No, it's for the Xbox.
Was it for the Xbox?
Yeah, there's Old Republic. There's Knights of the Old Republic, and then Knights of the Old Republic 2, and it's based off of the Jedi Civil War, where Revan and Malik go off to fight in the Mandalorian War. The Jedi Council tells them that they can't because you can't take sides. You're an arbiter. You're just there. And they say they look at all these free worlds that are being overtaken by the Mandalorians. They go off. They find what's called the Star Forge, which is just basically a giant dark side factory, basically. And it turns them to the dark side, and so all the Jedi who follow them end up getting turned to the dark side, which causes the Jedi Civil War, which is why when the prequels come out, there's not that many Jedi left. I mean, you basically have the Jedi Council, and they're rebuilding the Jedi Order, because the Jedi Civil War happened and basically wiped everyone out. But under the Old Republic, Revan ends up getting captured and getting his mind wiped, and he joins back to the light side and ends up taking out his old apprentice, who is now like the head of the newly formed Sith.
Sounds like a good video game.
It is, and I love it.
Sounds like a cool.
But see, I never played it.
And then it became an MMORPG type thing, like World of Warcraft, and it just became dumb.
Yeah, so right now,
And Disney has said that it's not canon, so
we've got Jedi Revan was released about 6 months ago. I couldn't get him. I didn't have because I won't put money.
you won't put money into
I
it.
won't
Then.
put money into it. I'm free to play only. Finally got Jedi Revan. Then they just released Darth Revan, and right now they just came out with Darth Malik.
Yeah.
But the only way to get Darth Malik is you got to have Jedi Revan and Darth Revan. It's like, man, forget it.
I love Old Republic.
You guys are killing me.
But supposedly they're making a Netflix series about it,
Yes.
which I really hope they do.
Netflix series.
Like live action Netflix
okay.
series based off of the Old Republic storyline. Which I don't really understand, because when you play the Old Republic games, you choose whether you're going to be dark side or light side.
Oh.
Well, Netflix has the option on some of the shows you can pick the story. But I don't
Yeah,
think
I've
it'll be
seen that. I've never watched
I don't think it'll be
You
that.
just show both sides.
but like you choose whether you want to kill people, you choose whether you kill the people that are supposed to join your group, and then
Does it really change the story at the
it
end?
does.
Oh.
Because either you end up taking over for like the dark side, or you end up being a Jedi, and it also depends on who's in your group and stuff like that. And I love them. But they're for the original Xbox.
Okay.
So if your son has an Xbox,
I had
It's
a
probably in
Xbox.
storage. It's one of those, but if you look at video of it, because I've seen like postings
There's a lot of
on it,
cutscenes in that game.
and it's not great quality. That's why I thought it was like a PC game.
It's both PC. It came out for PC and Xbox.
And
PCs back then weren't like as amazing either. So it's
Well, no, this was back like early 2000s because it was before I graduated high school.
Sure, that's what the Xbox time.
I hate it because you got all these whales and they're making all these Old Republic characters. Basically, they're in the meta and you can't beat them, and you just
Yeah.
Are they just they're impossible to beat?
Yeah.
They're just super strong.
Yeah.
Like, what are they better at?
They're just
faster?
stronger. Like I don't play the game that you're playing, but I just know like from canon, like the games they're just raw. Like the dark side now is like wimps compared to what they used to do. Like one of them is Nihilus or something like that. He is so consumed by the dark side that he is just like dark energy in like a form that's just covered in a robe, so you can never actually see him in the mask. And he literally just goes to planets and eats like all their energy.
Wow.
And that's what he does. He just drains the entire planet of its energy and kills it. Yeah, basically.
Yeah, right now the big ones it's Nihilus, it's Dark Scion, Dark Treya,
Yeah, Treya's an idiot.
of course Revan, and
there's Bastila.
now you got Bastila, and you got Jedi Bastila, and
And Dark
what
Bastila.
everybody refer to as Bad Stilla.
Bad
Because
stuff.
she's dark side. Bastila. And I'm like, God, you guys are killing me. Why can't I just kick somebody's ass with Han and Chewie? And no, not happening. You're not even coming close. Not gonna happen. So, all right, guys. And we are caught up.
yeah.
So how about chapter 14 next week?
Good.
And